Welcome back to the Stockwell Roche Show. I'm Jason Stockwell with Remax Results.
Jason Light with Envoy Mortgage.
And we are diving into changes in the Minnesota estate tax. And we got to meet and greet and learn about Susie King. She's with Moss & Barnett, an expert guest here today. We're very honored to have a lawyer in-house with expert advice on this because this is tricky for families, and it's also a touchy subject, and it's also a question of whether you do it or not. So we'll let Susie answer a ton of questions that Jason, Light, myself, and Robin have for her about this. And I guess we start off with the article. It's online, and you can find it on the website, lawmoss.com. We'll also put it on our Facebook page. It'll also be posted in our newspaper, in Edina Living, a smaller version of it, but the full article will be online. But what's the background of Minnesota state law, and what are the changes? What should people know about, Susie?
Yeah,
and that's a way open-ended question. So.
So generally speaking, Minnesota is one of only 19 states that imposes a state death tax. So in 2014, an individual can die owning $1.4 million, or excuse me, that's in 2015, $1.4 million. Anything over and above that may be subject to an estate tax. So, and those, what are known as exemptions, so the amount that you can own at your death, those are increasing. It'll be 1.6 million in 2016, 1.8 million in 2017, and then it's going to cap out at 2 million in 2018.
Okay, so 19 states do a death tax, and Minnesota, it sounds like, is being more generous, if you will, or letting people have more assets or more wealth before they can pass on, right?
You know, you may be the only person that's ever said they're being generous.
Well, if it's going
Really?
up from 1.4, 1.6, 1.8, 1 or 2.
Yeah, I mean,
sounds like
I
it's-
suppose, that shows that you look at the glass as half full most of your life. Yes, so I mean, to say that, yeah, we're giving you a pass. Well, you can die owning $2 million in a few years, and we won't worry about it. To a lot of people, it doesn't have that much of an implication. For some of more wealthy individuals, it is creating a cause for concern. And so this phenomenon, Minnesota's known as having snowbirds
Yes.
because of the weather. Now, this is just another reason for people to not have a permanent residency in the state. And that's unfortunate. It's becoming a deterrent to maintain their residency in Minnesota.
What do you mean by that? So, because it said non-residents. So if you're not so let's say you are a resident of Minnesota, you started coming into it, your business is doing well, and you have a lot of wealth, and you're getting an age, where you think, oh, maybe I'll be passing this on to my heirs, but I'm not able to in Minnesota, so I move, and then you're exempt from it, or you're not exempt from it?
Well, and this is a classic lawyer response. It depends.
Yeah.
So, there's a couple of moving parts here. One, for the Minnesota residents who have no thoughts about leaving the state or changing their residency, it's important to be cognizant that the exemption amount has changed.
Okay.
So that's first and foremost. The second are for those snowbirds who think that they are doing enough by simply physically moving out of the state to protect themselves from estate tax. The recent changes in Minnesota are saying you may not physically be a resident of Minnesota, but if you have enough ties to Minnesota, we're still going to tax on your death.
Oh, wow.
Whereas before, that wasn't the case. You could go to Florida and do some common estate planning tools to secure those assets from estate tax. And now the Department of Revenue is a little more aggressive in that.
So what would constitute enough ties?
Yeah, that's a great question. So there's a two-prong. If you can satisfy the residency test. So the Department of Revenue has this what's classified as an objective test of 26 factors to decide whether or not you are a resident of Minnesota. So if you spend 183 days in Minnesota and if you're not present for more than 183 days in Minnesota and you intend to make another place your residency, you will not be deemed a resident of Minnesota. And these factors are where was the location of the last time you voted? Where, these
So there's a 26-point litmus test on that. Wow.
essentially. Okay, so then let's get in the scenario that you pass that and you're deemed a non-Minnesota resident. That's the first hurdle. The second hurdle is, did you die owning Minnesota real estate? Okay, that's unquestionable. You will pay a Minnesota estate tax on it.
Oh.
The biggest change has been this, what's known as the definition of the situs of intangible personal property. And that's a whole lot of legal jargon to say, if you have an ownership interest in a pass-through entity, and the list of pass-through entities are S corporation, single-member LLCs, a multi-member LLC, and some trusts. If you have a membership interest in that, regardless of where that entity was incorporated, if that entity has real or tangible personal property in Minnesota, you are subject to Minnesota estate tax.
Oh, wow. So this may apply to you. If it does, great. You're doing very well, because we're talking about over 1.4 million usually on this, because my understanding is under that right now, you don't have any estate tax.
No, that's where the distinction is. So that there's an exemption amount for residents, and then you may still have to file a Minnesota estate tax and owe Minnesota estate tax even if you're not a resident. So at this, it's not necessarily, if you are under $1.4 million, don't worry about it. Because the filing requirements may be still applicable to you.
Okay, so walk me back on that real quick. Let's talk, folks out there. Let's talk about someone, regular person, normal, average income, and they over time they have a retirement account and assets and a house. When you add it all up, it doesn't take. You can get to $1 million,
Sure.
folks. I mean, it's possible.
It
You got a
is.
house. If you
A
pay that
cabin.
off, you've got your retirement, a cabin, maybe.
Yeah.
So let's say you get to $1 million or $1.2 million, and you're a Minnesota resident. What's the norm on that then? And you have kids at 1.2, and you live in Minnesota. You're not trying to move and all this stuff. What's the case?
Yep. So
Then it just goes to your heirs without any penalty, right?
yeah. So typically, what we see with spouses, if you have a husband and wife, we have planning in place that you can shed or credit some of those assets from Minnesota estate tax. So on the death of the first spouse, there's almost, and I say almost, never estate tax owed.
Okay.
It's on the death of the second spouse, what his or her gross estate is going to determine whether or not there's an estate tax owed.
Okay. So I have a question for you. Another question, Susie. And again, this is Susie King with Moss and Barnett, expert in this. So and you can tell it based on a lot of stuff she said. I'm confused a little bit already. So, so there's a lot going on here. But if you're, let's say you're at under 1.4, you're not worried about the tax. Do you still need to have an estate plan then?
Of course.
Okay.
I would say,
Because there's probably loads of people that don't, myself included. But
Yeah.
and going back to your question or your statement earlier, you just had your third child. That is a perfect time and an important time to have an estate plan for two reasons. One, if something were to happen to both you and your wife, you would want to be able to name the guardian of your minor children. You do that in an estate plan.
Okay.
And secondly, you want to be able to control how your assets, regardless of taxes, how your assets are distributed. So if you have multiple children, you can decide, I want them to be able to get distributions, a third at age 30, a third at 35, a third at 40.
So what's the normal? Let's say I do nothing. like most, so a lot of you out there maybe have had this exact situation happen with your parents or grandparents or something like that, where unfortunately your mom and dad both pass, and now you're stuck with the situation, and they didn't have an estate plan. What happens?
It's a mess. I mean,
It's a mess.
it is because particularly when you have multiple children involved, someone is going to have to be appointed personal representative, and
That can
without
cause
having,
a fight.
that
right?
can cause friction among
Yeah.
family members, and when there's no document in place to say this was mom or dad's wishes, it does wreak havoc on the family dynamics. Aside from the tax implications. I mean, if we
Just
don't
the
get,
emotional toll and the
Exact-
fighting and all that. Yeah.
yeah,
It's-
and estate planning, it does not have to mean what happens on your death as well. I do what I like to call a lot of planning for incapacity. So there are documents in addition to wills and trusts, for instance, a healthcare directive and a power of attorney, that are very important estate planning documents for while you are alive, but unable to make medical or financial decisions for yourself. So those are just as important as a will and a trust.
Yeah, there's like my family is in a situation right now where my mother is in late stage dementia, and they have to put her in a home. But my stepfather is in a situation where he is financially not able to do that, and he may lose his house.
Wow.
Yeah. And that's a prime example we should talk about.
Yeah, we'll be back with more. I hope you guys are engaged, and you folks, you out there listening, are loving this. I'm learning a lot, and hopefully can retain it. But Susie's here. Thanks, Susie. I'm Jason Stockwell with Remax Results.
Jason Light with Envoy Mortgage.
We'll be back soon. Stay tuned.
There's life after